My name is Gerald Parker. I'm the founding partner of Parker and Waichman. I've been an attorney for almost 40 years. Our law firm has one of the largest settlements of a tractor-trailer accident in New York State. The firm is large and well-financed, and we don't need a quick settlement to pay this week's bills. We look at each case individually, and we do that immediately because sometimes there might be other defendants involved in the case, and there may be certain things that we need to do quickly in order to preserve that evidence. What makes a good personal injury lawyer is someone who is thorough, not treating every case like it's a cookie cutter and we have an assembly line and we have a list of things that we have to do and get them done in order. You've got to look at every case because every case is different. Like every plaintiff is different. Like every defendant is different. Every case is different. Sometimes there are defendants that might not be apparent just looking at it on paper. But when you get out there, you're going to see that the stop sign is down, or the traffic light isn't working, or maybe a grocery store on the corner has a video camera outside that might have caught the view of what happened at that intersection. If you're just going to treat a case as any other case, as oftentimes does happen, then you're not going to get the benefit, and your client is not going to get the benefit, and you're not going to get the benefit of getting a totally thorough attorney, and that's what you need. Everybody who's involved in an accident and who is injured in any way needs an attorney. If you don't have an attorney, the insurance adjuster knows that and is going to take advantage of you. It's just that simple. They will underpay you on your case. No matter how much they give you, it will probably be about 20 to 30% of what you should have got. And there are two studies done in recent times by insurance companies that found that adjusters were able to settle cases for around 20 to 30% of the amount they would have paid if an attorney represented the clients. And that's on average. Of course, if you get an above average attorney who's more aggressive, has a better way to approach the case, you can get a lot more. But those are averages. You could sue for whatever amount that you want to put in the complaint. And we generally put amounts that are greatly in excess of what you are likely to receive. The reason being is because if you don't have a sufficient amount in your complaint, you then at a future date have to make a motion to amend your complaint to increase what they call the addendum clause. And I don't say this happens too often, but I've seen judges deny that motion. So we always put in an amount that's greatly inflated, because first of all, when we're suing, oftentimes we don't know the full extent of the injuries. The client might still be in the hospital. The client may still be under treatment. The client may still be out of work. How long are those things going to last? We don't know. So we put in a much greater amount than we're anticipating, so we don't run into the problem of having an amount that's too little and having to make a motion to increase the addendum clause. Also, maybe there was reckless conduct on the part of the defendant. Maybe the defendant was intoxicated. Maybe the defendant was on their cell phone. Maybe the defendant wasn't looking. Maybe the defendant was playing with their friends in the backseat while he's driving the car. Maybe there were all kinds of games going on in the car. Conduct like that might give rise to punitive damages. And so we need to plead a sufficient amount in the complaint to cover the client under all scenarios, and then we'll figure it out afterwards. Almost universally, personal injury attorneys work on what's called a contingency fee. If they don't collect, there is no fee. So it really won't cost you anything. At the end of the day, it will cost you a percentage. Different personal injury attorneys charge different amounts, different percentages. A lot of it is controlled by state law, but whatever it is, that personal injury attorney almost guaranteed will get you a lot more money for your case than you could do on your own. A lot more. Much more than the amount of the fee. The fee will not be consequential to you on the most cases when it's all said and done, because the insurance adjuster won't have the ability to lowball you. They know they're dealing with someone who knows what personal injury cases are worth, and they're not going to get away with giving you some low number that you'll grab, and then maybe a week later you're going to regret it. Everybody needs to hire a personal injury lawyer if they're injured. If you're involved in an accident with a tractor trailer, you need to call a lawyer immediately. There's a whole lot of reasons why. Just some of them are that there are federal laws that govern tractor trailer drivers and owners and operators. There's certain information on the computer systems that are in that vehicle and in the office of the company that runs that vehicle that is only required to be retained for so many days. And if you don't demand that information, that data is lost. And oftentimes that data is invaluable in proving your case. So you need a lawyer who's going to jump on that right away. And we have a experience in a major tractor trailer accident in upstate New York, causing catastrophic injuries to a 2-year-old baby. One of the saddest cases that I've ever experienced. And luckily, we had that data. And that data was very valuable. And once we finished discovery, that case resulted in one of the largest settlements in New York State history. If you're involved in an accident with a tractor trailer or a semi-truck, if you're injured, that's all that matters. There's all kinds of claims. Was the truck driver negligent? And it was an accident. Was the truck driver reckless? Was the truck driver drowsy? Were they under the influence of drugs or alcohol? Were they improperly trained? Was the load on the vehicle loaded improperly so that the trailer was not properly balanced? Was the driver driving recklessly or carelessly? These all go into factors that drive damages, because juries hate bad conduct. And if we could prove bad conduct, that's going to drive a much greater verdict. And if they know that we're going to be able to show bad conduct, that's going to drive a much greater settlement. So getting out there fast, interviewing those police officers fast, getting out there before the defendants, insurance investigators, being number one to the scene, speaking with all the people who possibly witnessed this accident or spoke to the defendants or spoke to your clients, that's extremely important. And what happens in the first few days of an accident drives the value of that case. That's why you need a lawyer, and you need a lawyer immediately. What the process is of filing a truck accident injury lawsuit is getting out there and speaking to the police officers who responded to the scene of the accident, speaking to any witnesses that might have been there. Maybe they're on the police report as a witness, and maybe they're not on the police report as a witness. You got to get out there and see who might have been there. If there's stores there, go knock on the store, go in there and speak to the clerk, see if they saw and what they saw, who they spoke to. Once you do your investigation, that case is ready to be filed. You file your lawsuit, you conduct the discovery of the defendant, you get that case ready for trial, and either they try the case or they settle the case. There's no other alternative. There is no such thing as a typical lawsuit involving a tractor-trailer accident. There's no such thing. There's no such thing as a typical. What's typical? Was the defendants negligent? Were they reckless? Were they careless? Were they drunk? Were they intoxicated? Was there a light that controlled the intersection? Was there a stop sign that controlled the intersection? What's the injury? How old is the plaintiff? Is the plaintiff in the hospital? Did they have any surgeries? Did they have a loss of use of an arm or leg? Are they mentally impaired as a result of the accident? Are they able to go back to work? And if so, how long? How much did they lose from their employment? Did they lose anything from employment? There's no such thing as a typical lawsuit. The truck accident lawsuit takes from the date of the accident until conclusion. It's going to vary. It's going to vary for a lot of reasons. First of all, it might vary because of the jurisdiction. If you're involved in a jurisdiction in an area where the courts are very busy, it might take a long time. If you're in what they call a rocket docket jurisdiction, it might take a lot less time. We've resolved cases in 6 months, 9 months, a year, and sometimes a lot longer than that. It really depends upon the complexity and where you are. Are you in state court? Are you in federal court? Federal court will tend to move a lot faster, and especially with truck accidents, it's likely the defendant is not from your state, and you can bring it in federal court, and there you're going to get a resolution probably within a year and a half, plus or minus, on average. Personal injury lawyers for truck accidents, like other accidents, are almost universally paid on a contingency fee. Very often the contingency fee is regulated by law, by your state law. In addition to the fee, the attorney is allowed to recover their expenses that they laid out for your lawsuit. In some truck accident cases, I've spent, maybe it's over $1 million in investigating the accident, having to hire accident reconstruction people. In one accident, we ended up suing the state of New York because the road was like a 180-degree angle. It was like a half a circle. And our client was coming up the road this way, and the defendant was coming up the road this way. The defendant was in a tractor trailer, so they were much higher, and they made a left turn into the side of our vehicle. And we didn't know if the insurance was enough to cover our client's injuries because our client was very, very badly injured. And we ended up bringing in the state of New York into that case because under the circumstances of having a road that's shaped like this at an intersection, we claimed that they needed to put up signs that said limited sight distance ahead, warning the truck that there was an intersection ahead where he has limited sight distance and he needs to slow down. They didn't have those signs, they didn't have those warnings, and it ended up that the state of New York was found to be at least partially responsible for that accident and helped us get a very good settlement for our clients during trial. So the question is costs. To bring in accident reconstructionists who are going to reconstruct the road in court so the jury can see it on maybe a 10 or 15-foot model showing the whole road on a side, like a slice of cake, and bringing in, the doctors and the surgeons and the rehab people and the people who are going to testify as to the future life of the client and what they're going to have to go through. Sometimes they cost a lot of money. They always cost a lot of money. But if the case is worth it, if it's sustainable, you want to bring those tools into this lawsuit because that's going to drive settlements. That's what's going to drive verdicts. And I know in our law firm, and I'm sure it's pretty much in most law firms, you're not going to invest that kind of money unless the case warrants it. Because all we're going to do is get back whatever we outlaid. We don't want to have money on the street that's at risk. So you need to have a law firm that has that kind of financial backing that is not afraid to go out and hire experts, accident reconstructionists, people who make models of roadways or models of cranes or models of whatever the instrumentality is. They cost a lot of money. One time we made a model of someone that was in a bosun's chair up on Broadway, and he was someone that worked, the lights in a Broadway theater, and he fell out of the bosun's chair. We had to make a model of the Broadway stage and the bosun's chair, and we had to show them why the bosun's chair was rigged improperly. These things take a lot of money. They take a lot of thought, ingenuity, creativity. You need a lawyer who has all those tools in their toolbox. If you're involved in a motorcycle accident, chances are you're going to be pretty seriously injured. The motorcycle always loses in those accidents. You need to have a lawyer that's very aggressive. You need to have a lawyer that's thorough, that gets out to the scene of the accident, speaks to the police officers before the insurance company for the defendant does, speaks to the witnesses before the insurance company for the defendants does, finds out if there's videotape from somewhere. Some cities are taping intersections. Some businesses might have some video cameras. You need to get all these pieces of possible evidence so that you could best formulate the claim on the behalf of your motorcycle client. Depending upon how the accident happened, sometimes the motorcycle has medical pay insurance. Sometimes it doesn't. Sometimes you can get the vehicle to pay for the insurance. Sometimes you can't. So you might have insurance from your employer. If the accident happened some other way, we'd have to look at the circumstances. If it happened as a result of a construction site failure or negligence, the construction site might have insurance. For example, if they had debris on the roadway, if debris fell in front of you and caused you to slam into the debris or slam on your brakes, there's likely to be some insurance from the construction site. It all depends upon the situation, but we do everything we can to find our clients medical insurance coverage so they can get the treatment that they need and deserve. Like all other lawsuits involving personal injury, lawyers throughout the country generally take these cases on contingency. You pay a contingency fee for the lawyer to represent you, so nothing is up front. The lawyer will even advance the cost of the litigation, and that would be advanced for you up front. All the lawyer recovers is when the lawsuit is settled or when you recover from a verdict. There is no money up front being paid by the client. If you're injured as a result of someone else's fault, whether it be a car accident, motorcycle accident, truck accident, or anything else, you should file a lawsuit. You should at least make a claim. You need to hire a lawyer. You need to have a thorough investigation and analysis of your claim prepared so you understand who you need to sue, what the benefits of suing those individual defendants are, what they bring to the litigation, and why do we need all those defendants. When you're involved in a car accident, the attorney's going to gather all the information that they need. In our office, if you're involved in a serious accident, we file that lawsuit usually within 24 hours. If the case is not that serious, we might take a look at it so we can get our arms around what kind of case this is. If you're still being treated by a doctor, we need to know what the results of that is. If you're out of work, we kind of need to understand how long you're going to be out of work. So we start gathering medical records, we get medical reports, we get our investigative reports, and we try to understand what kind of accident that we're dealing with, what is the liability, and what's the amount of damages or the type of damages we have. We might want to call the defendant up and say, do you have any interest in discussing this case? We might send them a letter including all of your medical records, including your records of your lost wages, including records from your pharmacy, all your expenses. Oftentimes they might want to talk about resolving the case. But if they don't, at least we're ready. And once we either they tell us they're not interested, or we feel that they're jerking us around, we file suit. You should get an attorney for a car accident or any other type of accident that causes your personal injuries immediately. Attorneys will try to get out there and interview the police officer, interview the EMS workers, interview eyewitnesses, both on the police report and those that are not on the police report, immediately before the defendant's adjuster or insurance investigator can get out there. The one that gets out there first is going to have a best shot at getting a statement in their favor. Accidents that lead to lawsuits are going to run the gamut, whether they're car accidents, truck accidents, motorcycle accidents, construction site accidents. You're going to have head and neck injuries. You're going to have fractures to various bones, dislocated joints, internal bleeding, brain damage, burns, spinal cord injuries. You could have loss of limb, and sometimes even death. There are some lawyers that have a rule of thumb based upon the amount of your medical expenses, and that's how they calculate the value of the case. We don't do that. We've never done that. We never will do that. We look at every single case. You can't use a calculator to figure out the settlement value of the case. You've got to look at all the evidence, because some of the evidence isn't in money. Some of the damages are in emotional damages. Some damages are inability to do things. What about if you're retired and you don't have any lost wages, but you're now stuck in a wheelchair, or you're using crutches? Those things don't enter into the calculus of amounts paid in medical expenses or lost wages. So in our law firm at Parker Waichman, we look at every case separately. We have a round table for every case at various times over the course of the litigation, where a whole bunch of lawyers get together and we all analyze each other's cases, and we come up with amounts that we think the case is worth and amounts that we will not take a settlement under. Maybe the case is worth 120, but our minimum settlement value is 100. The insurance company offers us 90, we're not taking it. So that's already hard-coded in our system. We just won't do it. We will give them a discount if they want to settle in advance. It's in the client's interest generally, because they're getting the money today. They also stop the expenses on a case. And of course, if you go to trial, there's vagaries at trial. So if the insurance company is going to get dangerously close to what you believe the value of the case is, it's generally going to be in the client's interest to settle. Conversely, if they don't get close enough, we have objective data in the case file in our computer system that tells us what those numbers are. And if they don't get there, the case is not going to settle, and we'll continue. Now, the case is the client's case. So if we get an offer, we have to communicate that to the client. Sometimes the clients want the money, even though our advice is not to take it. But at the end of the day, it's the client's case and we have to settle it. A lot of the times the clients ask us what we think. And of course, we give the clients our best thoughts on the pros and cons of what's on the table. If you've settled a car accident and you sign the general release, you cannot sue. Because if you read the general release, it says you're releasing the defendants from all claims, known and unknown, from when the accident happened in perpetuity. So unless there's something unusual, and we've had a few things that were unusual, that allowed us to get out of the settlement, allowed us to go to court and have the court vacate the settlement. Generally speaking, 99.9% of the time, you sign that general release, you're not going to be able to sue. And unfortunately, we've had clients that signed the general release before they had a lawyer. And that insurance adjuster for the defendant took advantage of that client. If I remember correctly, there was one case that was very tragic where the injuries were just horrific. The insurance company gave such a ridiculous offer that when we went to court, the court said that the amount of the offer was just so insignificant compared to the catastrophic nature of the injury that it was unconscionable, and vacated the offer and vacated the settlement. And then we were able to negotiate a reasonable settlement for the client thereafter. And not that long after in that particular case, but that's one case that comes to mind. But it's a very rare event, and that's why you need to hire a lawyer as soon as you can when you get involved in an accident, because those insurance adjusters will jump on you and take advantage of you every single day. Compensation in a car accident lawsuit is the same as any other kind of lawsuit involving personal injury. We're going to take a look at your medical bills. We're going to take a look at your lost wages. We're going to take a look at your costs of medication, prescription drugs, home health services. If unfortunately there was a death, we have to look at all those expenses. Mental pain and suffering. How long are these damages going to continue? How old are you? We take all this in effect, come up with the number. At Parker & Waichman, we're a very large law firm. We have lots of lawyers and paralegals that all they do is personal injury. Some of them have just been doing personal injury for their entire legal careers. We know damages, and we roundtable every single case with a whole bunch of lawyers. So you have other lawyers in the firm critiquing your case, talking about damages in your case, coming up with what the value of your case is. The cost to file a car accident lawsuit is the same to file most other lawsuits. Car accidents are a little bit less complicated, say, than a medical malpractice case. In a medical malpractice case, we need to possibly hire an expert. Some states require an expert affidavit indicating that the case has merit. Some require an attorney's affidavit saying you've consulted with a medical malpractice expert and they said it has merit. Sometimes you need to have an expert to tell you what exactly was the malpractice if it's not obvious from the records or from other information you have. But the cost for car accidents, the cost of hiring a lawyer for car accidents is the same cost for motorcycle accidents, truck accidents, tractor-trailer accidents. Filing a lawsuit after a bicycle accident is very similar to a motorcycle accident. The person on the bicycle is going to usually be very badly injured. You need a lawyer that's going to get out there and investigate it immediately. Get out there and talk to the police, the EMS workers, the witnesses, get the video if it's available, because it's likely, or maybe I should say possible, that the vehicle that hit you, if it's a vehicle, might not have enough coverage. Is there a street defect that's responsible for the accident? Is there a pothole that was caused by a utility company not filling in their holes? If the bicycle accident was caused by some other event, maybe not a vehicle, maybe there was a damage in the sidewalk that caused the tire to go into a crevice and get stuck, throwing you off the vehicle, throwing you off the bicycle. We've had a case like that. Client ended up getting thrown off the bicycle, hitting his head, catastrophic injuries. But you're not going to know that unless you get out there. Client's not able to tell you, talk to you. Client is in the hospital in a coma. You need a lawyer that's not afraid to leave their office and get out there and investigate the scene of a serious accident. Maybe there's a sign that's missing. Maybe there was a light out. There's a whole host of other possible ways the bicycle accident could have happened. But if you don't get out to the scene, you're never going to know that. You need a lawyer that's not going to be afraid to spend the time and get out there now. When the police report that the light wasn't working, how long do you think it's going to take the city to fix that light? When they know there was a big accident, they got to fix it in a minute. If the stop sign is down, it's going to be replaced in a day. If you don't get out there, you're not going to know it. You're involved in a bicycle accident, like a motorcycle accident, it's likely the personal injuries are going to be huge. Don't worry about the costs. They don't cost you anything. You're going to get a lawyer who's going to take it on a contingency fee. What you need to worry about is getting a good lawyer who's going to get out there and do the investigation that's needed immediately that day. They need to get out there and speak to the police, the EMS workers, the witnesses. I'll tell you this one story. I had a lawsuit involving pedestrians crossing the street. It was a holiday weekend, the 4th of July. I got a call in the middle of the night, about 12 o'clock, midnight. They told me about these pedestrians that were crossing the street and they're extremely injured or dead. I spoke to the family. The family wanted to meet me that night. I packed up my family. We were at a hotel and we came downstate and I met with the family at 4 o'clock in the morning. And then I also called my accident reconstructionist and told them to meet me there at the scene with the clients at 4 in the morning. You need a lawyer who not only is determined to have the best interest of the client at heart, has the resources to represent that client as best as it can be, and has the contacts with the experts where you can get an expert to the scene of an accident at 4 o'clock in the morning on the 4th of July weekend. It's hard to say who's at fault in a bicycle accident lawsuit until you analyze the facts. Is the bicycle driver at fault? Is the vehicle at fault? Is the municipality at fault because they don't have a sign? And is the utility at fault because it had a pothole in the road or the sidewalk? Is another vehicle at fault because it passed the red light, passed the stop sign, didn't yield the right of way? There are so many possible scenarios to bicycle accident lawsuits and to motorcycle lawsuits. But the thing is, you need to get the facts, and you need to get the facts the day of the accident. You need to nail down what happened that day because things change overnight. So the question is, can you sue for a bicycle accident if you're not wearing a helmet? The answer is yes. Now, if there's a helmet law in your jurisdiction, you need to read the helmet law. But it's possible that the helmet law is going to hold you at least somewhat responsible for the injuries that might have been prevented if you were wearing a helmet. Now, if you broke your leg, no helmet is going to prevent you from having a fractured leg. If you broke your arm, the helmet's not going to help you there either. If you sustained a brain injury, now we have to start considering what role would a helmet have played there. It may actually be an affirmative defense that the defendant has to undertake, that the helmet would have prevented your injury. They're going to need to bring in helmet experts. They're going to need to bring in doctors who are experts in brain movement because the brain is constantly moving within the shell. And they're going to bring in experts that are going to, and they're going to recreate that the vehicle hit you from the side and you went over this way, and then they're going to recreate on how your brain moved around within the skull. So it gets quite complex. But you need a lawyer who can think of those things, who are going to anticipate those defenses. They're going to hire their own experts early on so that they're ready for those defenses. And they're not going to be found short because they didn't anticipate it. And you need a law firm that has the money to expend on those kinds of experts, and they're very expensive. But if the injury is substantial, you have to spend the money, in my opinion. In our firm's opinion, You have to spend the money. We're well financed and we're not worried about spending the money when the expenditure is warranted. We just don't spend money willy-nilly. But if that client sustained a serious injury on a bicycle or motorcycle, they have a head injury, with or without a helmet law, I'm going to get an expert in there to talk about helmet because they might put the helmet defense in anyway. So if there's a law, the law is going to tell you how it needs to be analyzed. If there's no law, they're still going to claim that your client should have wore a helmet and that injury would not have happened, or the injury would have been much less than it was. And you need to have the experts that come in and the guys that do the graphics and the animation so that the jury could see that this helmet would not have had any impact in lessening the injury to the brain. You're injured in a pedestrian accident where you're got hit by a car, a bicycle, motorcycle, a truck, a tractor trailer. You need to call a lawyer immediately. That lawyer needs to get to the accident scene, interview the police, interview the EMS workers, the ambulance driver, look for the witnesses to document exactly what happened. They also need to see the condition of the street, the condition of the sidewalk. Maybe there's something in the street or the sidewalk that contributed to the accident. We need to know that for a lot of reasons. One is maybe they're possible defendants. Maybe the utility company didn't fill the hole right. When utility companies make holes, they've got to, usually, they have to put a mark in the street so you know which utility made that hole. We need to see that. We need to find out what they have. We need to get their records. You need a lawyer to help protect your rights. The main cause of pedestrian accidents that lead to lawsuits is inattention. Inattention by the drivers of cars, motorcycles, trucks, tractor trailers, also unsafe sidewalks, unsafe roadways, vehicles that ignore traffic laws and signals, speeding, driving while intoxicated, driving while impaired, distracted driving. Sometimes the vehicle might have a defect. Maybe the brakes weren't working properly. Maybe the steering wheel wasn't working. Those are potential defendants. And as I said earlier, just not yielding the right of way to pedestrians in the walkways. In my opinion, a driver is always at fault when a pedestrian is struck by their vehicle, whether it be an automobile, a motorcycle, a truck, a tractor trailer, what have you. Why? Because if the driver was looking at what was ahead of them, he would see the person walking out in the street. And he has a duty to avoid contact with that pedestrian. Even if that pedestrian is walking in the middle of the block, it doesn't give the driver a license to strike him. And you don't blow the horn, because the consequences of the pedestrian not hearing the horn, what happens if the pedestrian is deaf? The driver of a vehicle has an obligation to have their vehicle under their control all the time and not come into contact with pedestrians. Now, there are circumstances that maybe the pedestrian might also be at fault. Maybe the pedestrian ran out. Maybe the pedestrian ran out from between two cars and the car couldn't see it. But still, if the car was driving under the control of its operator, he should have put his foot on the brake. Is there a skid mark before the contact? If there's not, that means he wasn't looking. Because even if the pedestrian ran out from between two parked cars, the operator should have seen it and engaged the brake, even if it not enough time. But he should have been able to engage the brake, and that shows me, and that will show a jury, that that driver was not watching where they were going. Maybe they were watching the person on the left, they were watching the person on the right, they were talking to their colleague next to them, they were reaching down to change the radio. But if they were watching what was going on straight ahead, they would have seen that person at some time taken action. It would have been instinctive to hit the brake. And if they didn't hit the brake, that shows they weren't paying attention. Time to file a lawsuit for a pedestrian accident, like other personal injury accidents, is governed by the statute of limitations in your state. Generally speaking, in New York State, the statute of limitations for a negligence cause of action is 3 years. However, if you're talking about a medical malpractice case, it's going to be less, 2.5 years. If you're talking about a wrongful death cause of action, that cause of action for wrongful death, which is in addition to personal injury, is 2 years. And then there are other scenarios when you're going to be suing a state, a city, or other municipal agency where you might need to actually file notices as short as 30 days after the accident. Generally, those municipal cases are 90 days, but there are a few municipalities, municipal agencies in New York State where it's 30 days for the initial notice. You need to take a look at your state's statutes because these are regulated by state statute.